Welcome back, future criminologists. In this video, I will be discussing Writ of Habeas data. Writ of Habeas data. It is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. Sa ilalim ng remedyong ito, maaaring hilingin sa korte ng isang tao na ilabas, baguhin, itama, pigilin, o tuluyang sirain ng isang opisyal o ahensya ang anumang impormasyong nakalap nila hinggil sa taong nagpetisyon. Ito ay kung mapapatunayang illegal ang paraan ng pagkalap at ginagamit sa maling paraan ang nasabing impormasyon. Halimbawa nito ang illegal na pangangalap at paggamit ng impormasyon ng mga militar o ng kapulisan upang gantihan o di kaya patahimikin ang mga legal na personalidad na kabilang sa mga sinasabing makakaliwang grupo. The literal translation from Latin of habeas data is "you have the data." The remedy varies from country to country, but in general, it is designed to protect, by means of an individual complaint presented to a constitutional court, the data, image, privacy, honor, information, self-determination, and freedom of information of a person. What is the objective of the writ? Under the writ of habeas data, a person can compel the release of information, or to update, rectify, suppress, or destroy database, information, or files in the control of the respondents in a petition. The writ operates to protect a person's right to control information regarding himself, particularly in the instances where such information is being collected through unlawful means in order to achieve unlawful ends. Connection between right to privacy and right to life, liberty, or security. The writ, however, will not issue on the basis merely of an alleged unauthorized access to information about a person. Availment of the writ requires the existence of a connection between the right to privacy on the other hand and the right to life, liberty, or security on the other. Thus, the existence of a person's right to informational privacy and a showing, at least by substantial evidence, of an actual or threatened violation of right to privacy in life, liberty, or security of the victim are indispensable before the privilege of the writ may be extended. What is the connection between writ of habeas data and writ of amparo? In the Philippines, amparo and habeas data are prerogative writs to supplement the inefficacy of the writ of habeas corpus. Amparo means protection, while habeas data is access to information. Both writs were conceived to solve the extensive Philippine extrajudicial killings and forced disappearances since 1999. Ang batas na tinatawag na Rule on the Writ of Amparo na halos inulit lang sa Rule on the Writ of Habeas Data ay limitado lang sa pagbibigay proteksyon at pagtatanggol sa buhay, kalayaan at seguridad ng tao. Ginagamit ang mga batas na ito upang magbigay linaw sa malawakang pagpatay at pagkawala ng mga sibilyan o ang tinatawag na extrajudicial killings and enforced disappearances. Scope of the writ of habeas data. As an independent and summary remedy to protect the right to privacy, especially the right to informational privacy, the proceedings for the issuance of the writ of habeas data does not entail any finding of criminal, civil, or administrative culpability. Reliefs granted by the court. If the allegations in the petition are proven through substantial evidence, then the court may 1. Grant access to the database or information. 2. Enjoin the act complained of. Or 3. In case the database or information contains erroneous data or information, order its deletion, destruction, or rectification. Who may file a petition for writ of habeas data? An aggrieved party whose right to privacy in life, liberty, or security is violated or threatened may file a petition. However, in cases of extralegal killings and enforced disappearances, the petition may be filed by any member of the immediate family of the aggrieved party, namely the spouse, children, and parents, or any ascendant, descendant, or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity, who can be a subject to a writ of habeas data. 1. Any government employee or official. 2. Any private individual. And 3. Any private entities such as corporations. What acts are subject to a writ of habeas data? The acts subject of the writ are gathering, collecting, or storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. Where is the writ of habeas data enforceable? The writ of habeas data shall be enforceable anywhere in the Philippines. Quantum of proof in application for issuance of writ of habeas data. If the allegations in the petitions are proven by substantial evidence, the court shall enjoin the act complained of or order the deletion, destruction, or rectification of the erroneous data or information, and grant other relevant reliefs as may be just and equitable. Otherwise, the privilege of the writ shall be denied. Saan ito pwedeng isampa? Ang petisyong ito ay maaaring isumite sa Regional Trial Court or RTC kung saan nakatira ang nagrereklamo o kaya ang nirereklamo. Pwede rin sa Regional Trial Court na nakakasakop sa lugar kung saan kinolekta o inambak ang impormasyong tinutukoy ng petisyon. Depende na ito sa desisyon ng magpipetisyon. Maaari ding idulog ang petisyong ito sa Korte Suprema or sa Court of Appeals o di kaya'y sa Sandigan Bayan kung ang pakay ng nagreklamo ay pampublikong impormasyon na kinolekta ng isang ahensya o opisina ng gobyerno. To end, please subscribe to our channel and stay tuned for more videos.